So accountability for what happened during the G8 and G20 summits here in Toronto can take a lot of forms. Of course, the courts are one very important avenue, but there's a lot of activity happening outside the courts that CCLA is deeply involved in, and opportunities for individuals to seek accountability and transparency for what happened to them during the G20. So this little brief segment will give you an idea of what most of the different reviews and investigations are. Most of these are happening in Toronto or in Ontario, but we will have a chance to talk about the limited type of reviews taking place at the federal level. The most important review taking place right now is occurring through the Office of the Independent Police Review Director. This is a new agency established in Ontario whose doors only opened last November 2009. So the G20 poses probably its largest challenge to date, this agency, which is tasked with helping Ontarians bring complaints against the police and making sure those complaints are heard. So, as of about 3 weeks ago, OIPERD has said that they received hundreds of G20 complaints. Amongst these are 5 institutional complaints that CCLA had filed on behalf of our organization. In addition to that, CCLA marshaled 85 individual complaints from the public, from individuals who saw things they thought were unconstitutional or illegal during the G20, all the way up to individuals who suffered what they termed to be assaults and unlawful detentions during the G20. OIPERD announced about 3 weeks ago that they had received so many complaints relating to the G20 that they would conduct what's called a systemic review of G20 policing. Now what that term means is somewhat up for grabs still, as this is the first time OIPERD has ever conducted a systemic review. But the director has identified 4 areas that he wants to look at, including unreasonable detentions, unlawful arrests, unreasonable searches, and the conditions in the Eastern Avenue Detention Center. CCLA has asked him to also look at the issue of the dispersal of peaceful protesters by force. So OIPERD right now is currently moving through the hundreds of complaints they have, and as we said before, because the process is new, there are already issues that are coming up that are of concern to us and to the public. Amongst these is the fact that OIPERD has decided to forward almost all of the complaints dealing with officer conduct to the local municipal police authority, which here in Toronto is the Toronto Police Services, for investigation. Now, OIPERD doesn't have to do this. They have the authority to retain the complaint and investigate it themselves, but due to the volume, they've actually decided that all complaints will likely go to the Toronto Police Service to investigate. And whenever you have a police service investigating themselves, there are obvious concerns for transparency and effectiveness. The other concern is about the manner in which police are following up on the complaints. Several complainants have been asked to either come to a police station or to have the police come to their homes, which also raises concerns about the fairness and the comfortability for complainants, and how effective the process can be when people feel either re-traumatized by it or don't feel the process is open or effective for them. The second police review that's been initiated here in Toronto is a review by the Toronto Police Services Board. The Police Services Board is an all-civilian agency that's tasked under the Police Services Act with monitoring the policies and conduct of the Toronto Police at a very high level. They're not responsible for individual day-to-day misconduct by officers. That's the purview of the Ontario Independent Police Review Director, which we spoke about before. Now, the Toronto Police Services Board has announced that they will have an independent civilian review of G20 policing that's going to focus on things like governance and chain of command and communications. As you are aware, likely, during the G20 summit, it was not only Toronto police here in the city. Police officers were brought from across the country, from places like Calgary, from Montreal, from Victoria, to join the policing effort here. And outside of the policing fence, most of the chain of authority led to the Chief of Police at the Toronto Police Services, William Blair. So that review has not actually begun yet. The Toronto Police Services Board is actually in a very long process of figuring out what exactly their jurisdiction is and how much or in what content the independent civilian reviewer can look at. Actually, tomorrow, which is Thursday, August 26th, the Toronto Police Services Board is scheduled to finally release the terms of reference for the independent civilian reviewer. Those terms of reference, CCLA has actually submitted proposals on what they should include, as have other members of the public. So we're also eagerly waiting to see what the Toronto Police Services Board will include in the terms of reference and who the independent civilian reviewer will be. That process is anticipated to take about another 12 weeks after the terms of reference has been announced. So hopefully we'll have a report from the Toronto Police Services Board sometime in November, potentially. One important review that's taking place is by the Ombudsman of Ontario. The Ombudsman is there to look at the type of consultation and transparency and decision making in Ontario. And of course, the Ombudsman was very concerned with the adoption of Regulation 233/10 under the Public Works Protection Act. Most people will more commonly know this as the 5-meter rule. Under this regulation, a huge swath of downtown Toronto was declared to be a public works under the Public Works Protection Act. This included not only the convention center, but condominium buildings, hotels, Union Station, large areas of what we traditionally consider to be public spaces in downtown Toronto. Under the regulation, the police had the authority to stop and search and demand ID from any person found within the zone. Anyone who did not cooperate could have been arrested. This regulation proved very controversial, not least for which it was passed quite in secret in early June by the provincial government with almost no consultation or notice to the public. It appeared on the e-laws directory, which is a website, without any real notice from the government, and came into effect in the week before the summit. Now, the regulation did lapse in the days after the summit, but while the summit was going on, the regulation posed a stark change in our constitutional law as we know it. Under normal circumstances, an individual walking on the street has no obligation to speak with police, no obligation to produce ID, and the police have no authority to conduct a search without a warrant. So the regulation really turned our constitutional liberties on its head, and there was a lot of concern that there was no notice and no consultation for the adoption of this regulation, and that the government was quite quiet about it until it announced its existence literally 2 days before the summit began. The Ombudsman is currently conducting an investigation into the appropriateness of the process that was taken about to adopt this regulation. The Ombudsman cannot look into the wisdom of the regulation itself. That's a limit on the Ombudsman's jurisdiction. He can only look into process. So, of course, the question of whether the government should have ever adopted Regulation 233/10 and whether the powers the police had originally were sufficient under the common law or under other statutes cannot be addressed by the Ombudsman, and that's a serious gap in accountability under the Public Works Protection Act. At the federal level, there are a limited number of reviews that are taking place. Now, the most important reason for this is that Parliament is not sitting right now. They are currently in their summer recess. Perhaps the most important review taking place right now is by the Auditor General of Canada, Sheila Fraser, who is conducting a review into the enormous expenses that were occasioned by the G8 and G20 summit. As you may be aware, about $1.1 billion was set aside for the summit, $930 million of which was for security alone. So the security budget of the summit will be a close topic of scrutiny for the Auditor General, and CCLA has made submissions to her to discuss the close connection between excessive spending on security and infringements or chilling on freedom of speech on the ground. Excessive numbers of police officers, excessive and unnecessary military equipment on the streets can cause people to be concerned for their safety and cause people not to go out and demonstrate and protest, as is their democratic rights. So we've made submissions to the Auditor General to closely connect excessive spending with constitutional liberties of Canadians. The other review that occurred this summer at the federal government was a special meeting of the Standing Committee for Public Safety, which is the House of Commons committee most closely tasked with looking into the G20. Now, they had an emergency meeting on July of this year, and at that meeting they were hoping to pass a resolution to have emergency review or an emergency investigation of the G20. That resolution did not pass the committee, so we are now waiting for the House to sit again, as it will in September, at which point the G20 is supposed to be the first item on the agenda for the Standing Committee on Public Safety. So as you've heard in this segment, there are a lot of very isolated and very fragmented reviews taking place at the provincial level, at the municipal level, and a few at the federal level. What these reviews do not do is they do not speak to each other, and they do not cover all of the issues that are raised by the G20. Most importantly, the decision makers that are perhaps most responsible, those at the federal level, those who hosted the summit, those who paid for the summit, and those who took a lot of the credit for the successes of the summit, that being the federal government, are doing very little to review the activity of the G20, and we believe answers for what happened during the G20, in particular the abuse of civil liberty, must come from Ottawa. So Canadian Civil Liberties Association has called for the government to have an independent inquiry, whether under the Public Inquiries Act or under another body, but the inquiry must be independent, it must be comprehensive, it must have national security clearance, and it must involve the participation of the public.